After 16 years.
Yes, he is writing in response to a question asked by Mr. Sayyid Rafi Raza, who was conducting interviews for this book. Mr. Sharifuddin gave him this signed.
What is the worth of this document?
My lord, only to set the background, nothing else.
नहीं तो खैर चलें, it's neither here nor there. It took 16 years for him to write this thing letter.
It's in similar vein. It is in similar
But
vein.
there the author judge had said something, so it has direct nexus.
Yes,
but
my
this
lord.
piece of paper, what is it? Show.
Mercy petition was filed by Begum Bhutto.
Yes, there were two petitions.
If you don't mind, please have a seat. We are hearing amicus, and we will let amicus finish. You can have your say. Please make the old-fashioned way of proceeding was make a point. If you don't agree with anything the amicus says, we'll hear you at your time. Otherwise, we won't make any progress. Tashreef rakhein Kasuri sahab.
There were a number of mercy petitions, insofar as I am aware.
What is the worth of this piece of paper?
My lord,
16 years after the event, you write. What does it mean? I don't know.
it's probably setting the record straight.
What record?
That when asked by the author of this book in the context of how the sentence was executed,
Still, it doesn't change anything.
It doesn't, because it's much after the execution.
Let's forget this.
Yes.
Let's proceed.
So, I was only drawing your lordship's attention that this is probably the only other piece of writing, or you may say, which is on the record of one of the persons involved.
Pizarda's conscience did not prick him for 16 years.
And my lord, your lordship also has that video testimony, which will show.
ये तो अजीब बातें हो जाएंगी ना. We're going to realm completely sort of.
It only shows that he was pointing out that
If we accept that this has even been written by him, first of all,
yes,
then why does he take 16 years to write it? So these are too many ifs and
the
buts here.
authenticity of this has recently been confirmed in an article written by Mr. Waqar Rana, who had worked with Mr. Pirzada.
You have worked with Mr.
Yes, I have.
Sharifuddin Pirzada.
Yes, my lord.
Did he own up to this thing?
My lord, I am not aware of this. I am not aware of this.
Chalen, let's proceed.
So,
आगे बढ़ें.
my lord, yes. My lord, my submission before your lordship is that the 4 questions as framed by your lordship are already on the record. That was a differently constituted bench, but they are part of the order of 12th of December 2023 as well, where your lordships identify these questions. On page 3 of your lordship's order. Your lordship says, paragraph 6, the first and foremost constitutional and legal points, in addition to those recorded in order dated 21st April 2011 that require consideration, are whether the presidential reference is maintainable under Article 186 of the Constitution, whether the presidential reference requires a factual inquiry, and if so, whether under Article 186 of the
आप बताएं ना, अपना बताएं ना, we know what we've written.
My lord, yes. My lord, my respectful submission before your lordship is that Mr. Zulfiqar Bhutto was convicted and sentenced to death in view of the judgment of the Supreme Court in PLD 1979, Supreme Court 38. This, my lord, my submission is that is not to be treated as an ordinary criminal case, because, as I said, it is one of those rarest of rare cases in common law jurisprudence where the sentence having been carried out as a result of a 4-3 conviction, one of the judges in majority thereafter gave a press interview saying that the judgment was obtained under pressure. If that was the case, the principle of nemo iudex in terms of natural justice comes in, and there are 2 situations in which your lordships have said which will unravel any judgment of any court. One is that of fraud, and the other is bias. So if
you applying 12.2 principles?
I am not applying 12.2, I am applying the nemo iudex principle. That if a person is affected by any consideration except the due process of law and the facts before the case, then the principle of nemo iudex comes in. This honorable court has...
Now we are going into the merits. We wanted you to attend to the constitutional
My lord,
law of the land first.
This is the constitutional...
This is maintainability.
This is the constitutional submission is based on Article 4 of the Constitution, which I say incorporates the principles of nemo iudex.
Can we read Article?
Yes, my lord.
Sure.
To enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. In particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. No person shall be prevented from or be hindered in doing that which is not prohibited by law, and no person shall be compelled to do that which the law does not require him to do. I particularly emphasize, my lord, paragraph 1, the first paragraph, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen, wherever he may be, and of every other person for the time being within Pakistan. And second, in particular, no action detrimental to the life, liberty, body, reputation, or property of any person shall be taken except in accordance with law. And where therefore any other consideration except due process infects a judgment that, with great respect, cannot be sustained under Article 4 of the Constitution.
Why are you not adding Article 9 also?
My lord, my lord, your lordship is absolutely right. May I point out why I haven't referred to it straight away, and I would refer to 10A, but that came later.
10A wasn't there then.
There is reason. If your lordship looks at the language of paragraph 1 of Article 4, to enjoy the protection of law and to be treated in accordance with law is the inalienable right of every citizen. The Constitution recognizes that this is a right which even precedes the Constitution. This is a right which is not being conferred upon by the Constitution. This is an inalienable right of every citizen. Contrast that, my lord, with the language of Article 8, paragraph 1, which is the Fundamental Rights chapter, and that straight away leads us to Article 9. Any law or custom or usage having the force of law, it talks about shall, so far as inconsistent with the rights conferred by this chapter, shall to the extent of such inconsistency be void. Your lordship is to see the language insofar as it is inconsistent with the rights conferred by this chapter. So over here, your lordship have rights which are conferred by Article 8 and the chapter on fundamental rights of the Constitution. Your lordship must see paragraph 2.
You are saying Article 4 rights are inalienable rights, and Article 10 rights, which are the fundamental rights, are conferred rights.
And
so the inalienable rights take preeminence over conferred rights.
My lord.
Correct?
Correct, my lord. And I say that, my lord, the word conferred is used in paragraph 2 as well. And your lordship will see there too.
G.
They talk about, and as your lordship is well aware, that these rights, the fundamental rights, can be suspended under the emergency provisions of the Constitution when an emergency is invoked. And at the time,
Which is that provision?
my lord, the emergency provisions are Article 232 onwards, but if your lordship is looking for
particular
the
provision.
Article 233, paragraph 1, where certain rights are suspended the moment a proclamation of emergency is made. nothing contained in Articles 15, 16, 17, 18, 19, and 24 shall, while a proclamation of emergency is enforced, restrict the power of the state as defined in Article 7 to make any law or take any executive action, so on and so forth, my lord. And if your lordship then turns to paragraph 2, while a proclamation of emergency is enforced, the President may by order declare that the right to move any court for the enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2 as may be specified in the order, and any proceeding in any court which is for the enforcement or involves the determination of any question as to the infringement of any of the rights so specified shall remain suspended for the period during which the proclamation is enforced, and any such order may be made in respect of the whole or any part of Pakistan.
Sub-Article 2 only deals with 15, 16, 17, or it encompasses all the fundamental?
My lord, it encompasses all the fundamental rights, because over here, the President may by order declare that the right to move any court for enforcement of such of the fundamental rights conferred by Chapter 1 of Part 2.
Was an order in the field when the trial and the appeal took place?
Yes, my lord.
Which is that order?
My lord, after 5th July 1977, when the proclamation of emergency was made, the Constitution was put in abeyance.
Where can we read that?
My lord, I will find it in a moment and place it before you.
PLD 77.
PLD 77.
आपने कहा ना proclamation of emergency क्या था?
जी सर. और
77 में होगा PLD.
So for one no
Federal statutes.
So for one no order has to be made. Under paragraph 1 no order has to be made. It happens automatically by the operation of law by the
One doesn't attend to Article 9.
But under 2 an order has to be made.
Bhutto, can I take you back a little?
My lord.
I want to understand what is the question of law that's been placed before us? Is the question of law to revisit a judgment of this court, or is the question of law that the judgment has to be revisited for two reasons, because one of the judge made a statement, or because the country was passing through a period of deviation? And would that not entail, is that the question of law?
No, my lord. The second is not the question of law. It's the first which is the question of law. And my submission based on that first question of law, that Article 4 of the Constitution never having been suspended, and Article 4 of the Constitution, as this Honorable Court notices in the case of Ghulam Mustafa Khar, PLD 1989, Supreme Court, page 26. This was actually even made a part of the PCO, so even the military regime of that time continued with this article and observed that all these requirements will be observed. That in view of that, any order which has been passed in violation of the due process of law can be revisited by this Honorable
You
Court.
say is because of that interview.
Because of that interview,
Would that not then require a further inquiry into a factual situation as to what the interview was, what did he say, what would the pressure really mean? Are we also supposed, and I want to understand this, that 186 is a question of law, we just answer the question of law as the question of law is? Or are we to investigate further that what is the reason for that question of law, that being an interview according to you? Could we go into the interview? Could we then call people, find out what, could we get into this phase of inquiry to answer the question under Article 186, or is it simply a question of law without an inquiry?
my lord, it is a question of law that if it comes to light that a particular judgment was a result of considerations other than the due process of law, then that judgment by itself becomes questionable.
But this factum that it was otherwise requires inquiry. We can't just simply look at a video and say this happened. What about the other judges? There are a number of judges on the thing. So, what I want to legally understand is that when we start addressing a question under 186, Is it just a legal question, or this might, as in this case, entail looking at evidence and then also the veracity of that evidence, the interpretation of that evidence? Are we going to entail that, get into that exercise also?
My lord, the immediate response will be based on two
I
judgments.
want to add one more thing.
My
That
lord.
can you point out any specific question that is being posed to us in the reference that is to be answered? Specific question for the Supreme Court.
My lord, this honorable court itself has posed...
No, in
two questions.
reference. In reference.
My lord, the reference is before your lordship.
Then we should be confined to that question.
My lord, no, your lordship has now framed questions, but if your lordship is looking at the reference on pages 16 to 18, the questions were framed at that time. But I'll read those in a minute, they're here. But in order to answer my lord, Mr. Sayyid Mansoor Ali Shah's question, my lord, this arose in the context of an appeal before this honorable court, so the issue was open at that time, and it arose in a context where the proceedings had finally concluding in the House of Lords, as it then was called, in the United Kingdom. In the Pinochet case, the House of Lords, again by a narrow majority, had come to the conclusion that Mr. Pinochet needs to be extradited. An issue arose, and your lordship knows that ordinarily the House of Lords never reviews its judgments. Once they have given a judgment that's final, concluded, and the proceedings were over. But an application was made that Mr. Justice Hoffman, who was one of the members of the majority, his wife was part of the Amnesty International, and Amnesty International had submitted an amicus brief.
That was a review, was it?
My lord, but your lordship knows that unlike in our case in the
That would
Constitution of
certainly happen
Pakistan,
if we were to decide a matter. Somebody could file a review and say that one of the judges had a... So I want to really understand the jurisdiction under 186. That a question of law, as I understand, is that this judgment is wrong. Fair enough. Can we just look at it? Can we then revisit the judgment and say it is wrong, or don't we relying on some extra material now, which you say is the interview, which requires inquiry? Could we just take the interview on the face value, or are we to then find out what the text meant, or are we to, some people need to come forward, do we need to cross-examine, do we need to get into all this, or just take the interview on the face value? And that's just one judge. There are a number of other judges who are not saying anything. Maybe they were not under pressure, or they were, we don't know. So my legal question is, are we to dive into an inquiry? Is that envisaged under 186 is my question.
जैसे जरा सा मैं अपनी तरफ से जरा बात करना चाह रहा हूँ। जो अब आपने बातें की हैं आर्टिकल 4 की, जो आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, चाहे 233 के तहत भी नहीं किया जा सकता है। आर्टिकल 9 की एक अलग बहस है, मगर अगर आर्टिकल 4 कभी भी ख़त्म नहीं किया जा सकता है, तब ये हम बात क्यों नहीं कर सकते हैं, इस केस को अलग रखें, मगर हर क्रिमिनल केस में जहाँ के प्रोसिक्यूशन में एलिमेंट ऑफ पॉलिटिक्स इन्वॉल्व हो जाए, नेचुरली एक वक्त में जबकि आइन सस्पेंड हुआ है या एब्रोगेट हुआ है, तो हर को क्यों नहीं राइट मिले दोबारा अदालत का रुख करने के लिए कि जी आर्टिकल 4 तो आपने नज़रअंदाज ही कर दिया, तो आपने कहा कि सिर्फ और सिर्फ ये हम इस केस को देख सकते हैं, हम सारे ऐसे केसेस को क्यों ना देखें? ठीक है, वहाँ अगर मगर आर्टिकल 4 को देखने के लिए कि दरवाज़ा खुलता है या नहीं, मेरे हिसाब से आपको केस में जाना पड़ेगा। आप सिर्फ ये कह सकते हैं तो नहीं है कि जी क्योंकि उस ज़माने में माशाअल्लाह लगा हुआ था तो फलां शख्स को फांसी हो गई तो ये अनकॉन्स्टिट्यूशनल हो गया। नहीं, आपको थोड़ा सा और मेहनत करना होगी कि आर्टिकल 4 का तो आपको दरवाज़ा है, मगर आर्टिकल 4 के दरवाजे को खोलने के लिए आपको कुछ हमें बुनियादी चीजें दिखाना होंगी। ये जरूरी नहीं कि इसी केस में हो, दूसरे केसेस में भी हो सकता है, मगर वो अब देखेंगे अगर सदर साहब मुनासिब समझें कि वहां भी रेफरेंस भेजें, क्योंकि रिव्यू का जुरिसडिक्शन खत्म हो गया, तो फैसला तो खत्म हो गया हर लिहाज से, अब रह गया सिर्फ ओपिनियन। तो मैं तो कहूंगा कि अगर आपकी बात को हम आगे ले जाएं और लॉजिकल कंक्लूजन पे ले जाएं, तो हर केस में हम कर सकते हैं ये, अगर नंबर 1 वो उस वक्त में कॉन्स्टिट्यूशनल डिपार्चर हो, पहली बात। दूसरी बात ये कि आर्टिकल 4 के आप प्राइमा फेसाई केस आप एस्टेब्लिश कर पाए। तीसरी बात फिर ये होगी कि ठीक है, आर्टिकल पहली बात भी हो गई, दूसरी बात भी हो गई, मगर हर केस इस बुनियाद पे नहीं खत्म हो सकता है, उस पर ओपिनियन नहीं दिया जा सकता है, मगर उसमें आपको कुछ मजीद दिखाना होगा, और वो मजीद दिखाने के लिए इस केस में एक जज साहब का इंटरव्यू है, दूसरे केस में शायद कुछ और हो सकता है कि वो डीएनए एविडेंस आ गई हो, फॉर इंस्टेंस, कि जो जमाने में डीएनए नहीं होती थी, डीएनए एविडेंस आ गई है। तो ये आप इससे एग्री करेंगे या आप इससे डिसएग्री करेंगे?
My lord, I would most respectfully agree with it, because I would respectfully submit that this is something which is now happening in the other jurisdictions of the world as well. In some cases, it is happening in the context of the state having recognized.
आपको बता रहे हैं जुल्फिकार अली भुट्टो के खिलाफ सदारती रेफरेंस के ऊपर समाअत जारी है। 9 रुकनी बेंच इसकी समाअत कर रहा है। आगे बढ़े, आपको बताएं लाहौर हाई कोर्ट रावलपिंडी बेंच,
and he had no authority to speak on behalf of other members of the bench. I left for New York on 30th March and underwent bypass surgery. In the meantime, the Law Ministry and the Law Minister, Mr. A.K. Brohi, in their opinion on the summary to the President, observed, Allah the Almighty has clearly provided as to how the murderer is to be dealt with. He does not permit of mercy to a merciless by the judge or the president. The authority that allows merciful commutation of a sentence is merciless of the deceased, his heirs and his relatives. Mercy, remission or commutation is negation of justice, and justice is not only to be done to the killer who is surviving because of legal formalities, but also to be done to the deceased who cannot be heard but whose soul looks for justice. The revenge, death for death, and that in fact is the humanitarian consideration. On 1st April 1979, the President rejected the mercy petition and Mr. Bhutto was hanged on 4th April 1979.
Now, 2 questions. First of all, on